The first requisite for the exercise of the power of judicial review is that there must be an actual case or controversy. Actual case or controversy involves a conflict of legal rights, an assertion of opposite legal claims susceptible of judicial resolution as distinguished from a hypothetical or abstract difference or dispute. Closely linked to this requirement is that the question must be ripe for adjudication, that is, when the act being challenged has had a direct adverse effect on the individual or entity challenging it. It is a prerequisite that something had then been accomplished or performed by either branch before a court may come into the picture, and the petitioner must allege the existence of an immediate or threatened injury to itself as a result of the challenge action. There must be an existing case or controversy that is appropriate or ripe for determination, not conjectural or anticipatory, lest the decision of the court would amount to an advisory opinion. The requirement of ripeness, so to repeat and to emphasize, corollary to the requirement of an actual case or controversy is the requirement of ripeness. A question is ripe for adjudication when the act being challenged has had a direct adverse effect on the individual challenging it. For a case to be considered ripe for adjudication, it is a prerequisite that something has then been accomplished or performed by either branch before a court may come into the picture, and the petitioner must allege the existence of an immediate or threatened injury to himself as a result of the challenge action. He must show that he has sustained or is immediately in danger of sustaining some direct injury as a result of the act complained of. It must not be moot or academic. The case must not be moot or academic or based on extra-legal or other similar considerations not cognizable by a court of justice. Stated otherwise, it is not the mere existence of a conflict or controversy that will authorize the exercise by the courts of its power of review. More importantly, the issue involved must be susceptible of judicial determination. The rule is that courts do not sit to adjudicate mere academic questions to satisfy scholarly interest, however intellectually challenging. The controversy must be justiciable, definite and concrete, touching on the legal relations of parties having adverse legal interests. In other words, the pleadings must show an active, antagonistic assertion of a legal right on the one hand, and a denial thereof on the other. That is, it must concern a real, tangible, and not merely a theoretical question or issue. There ought to be an actual and substantial controversy admitting of specific relief through a decree conclusive in nature, as distinguished from an opinion advising what the law would be upon a hypothetical state of facts. So here are some examples of cases when there is no actual case or controversy. Mere academic questions. In the case of Paco versus Secretary of Education, the Supreme Court held that in order that a memorandum or circular issued by the Department of Education may be constitutionally assailed, the circular or memo must be indicated, the wrong inflicted or threatened must be alleged and proved, and the constitutional point raised and argued specifically. Mere apprehension that the Secretary of Education might, under the law, withdraw the permit of one of the petitioners does not constitute justiciable controversy. In another case, the Supreme Court held that petition posed in the abstract, a petition for an advisory opinion, as when in a petition seeking to nullify a law disqualifying retirees, but petitioner has not been sought to be disqualified just yet. Another example, the Supreme Court held that there can be no justiciable controversy involving the constitutionality of a proposed bill. The court can exercise its power of judicial review only after a law is enacted, not before. Mijares wants the court to strike down the proposed bills abolishing the Judiciary Development Fund. The court, however, must act only within its powers granted under the Constitution. The court is not empowered to review proposed bills because a bill is not a law.